Well, hello to everyone who's joined us today, and welcome to this webinar. Let me say a few words by way of introduction before introducing our speakers. It was in April of this year that a group of us, under the auspices of the British Institute of International and Comparative Law, drew attention to the risk of a plethora of disputes impeding the recovery from the global crisis that has been produced by the COVID-19 virus. That included, I may say, two former presidents of the UK Supreme Court and a number of others of us. In May of this year, and again in September, we published an analysis of the disputes and the kind of issues that were being raised in these disputes internationally, at least so far. Today, we're looking at the third and in many ways the most important part of what we call the Breathing Space project. We've produced a set of guidelines for the resolution of disputes in the pandemic. And these are aimed at those who have responsibility for commercial dispute resolution, both in terms of parties, but also in terms of those advising parties. Among other things, they take account of the public interest that this pandemic has generated. Two of the authors, Helen Dodds, the former head of global dispute resolution at Standard Chartered Bank, and Guy Pendle, who is a commercial disputes partner at CMS, are going to speak to us first today. The third author of these guidelines is Adam Johnson, now Sir Adam Johnson, who became a High Court judge a few weeks ago. They are all, and I'm sure I don't need to tell you this, distinguished commercial practitioners with a vast range of experience between them. How we're going to proceed is that Helen and Guy will both introduce the guidelines. They are, of course, available on the BIICL website. If you are at your computers and you want to have a look, if you put in breathing space and BIICL, you will get through to the page and you can find them there. They will be followed by what, if I may say so, is an equally distinguished panel. And let me take a moment now just to introduce them in order of speaking. First, John Howells, who is Member of Parliament for Henley with a distinguished career in media and journalism before becoming an MP in 2008, and he chairs the all-party parliamentary group in alternative dispute resolution. Joan Cross is the Assistant General Counsel for dispute resolution within the BP group. Janbo is a leading arbitrator based in arbitration chambers in Hong Kong. John Fellis is a partner in the New York office of Hughes Hubbard and Reed, and who chairs the firm's arbitration practice. Well, that is all I want to say in opening, and I'm now going to hand over to Helen and to Guy.
Thanks very much, Bill. And I think we've got a few slides for you, although not too many, as we talk you through the guidelines and what we see as their and hope their purpose will be. So we believe that the guidelines are consistent with the concept notes 1 and 2 on how the legal and business communities might respond to the pandemic in order to foster economic recovery. So we see them as part of a natural progression from those notes. And we'd also like them to become a point of reference for the business as well as the legal communities. In the main, they are a set of practical guidelines with the emphasis on practical. And our aim was to create something simple, clear, and flexible that could be used by businesses throughout the world in any jurisdiction, and which would be compatible with any legal dispute resolution system and aligned with a range of international government initiatives. The guidelines are not intended to be a code of conduct that must be signed up to. Rather, they can be adopted at will by one or all parties, and where relevant, their litigation funders, on a case-by-case or more general basis. They're intended to enable the parties to think beyond formal legal system parameters, rather than being constrained by these. And they shouldn't be weaponized or used to disadvantage other parties. We expect them to be of most relevance in the world of commerce, and so we've focused on contractual relationships, but they could apply to a wider range of disputes. For example, they may be useful in cases involving economic torts, such as procuring breach of contract and fraud, and issues such as mis-selling and misrepresentation. We want them to encourage a more conciliatory approach to contractual disputes by prompting parties to seek out and explore the many alternative dispute resolution options that are already available. And we hope they can provide a roadmap for those who are less familiar with managing disputes, helping them to understand the options open to them, to resolve their problems, and to realise they're not inevitably headed down the road to court. For example, smaller businesses may find that they have legal disputes with other parties with whom they may have previously had good business relationships, and may be seeking guidance on how to address the disputes while still preserving those relationships. The guidelines seek to avoid or minimise protracted legal disputes by encouraging parties, when they do have more traditional legal cases in court or in arbitration, to manage them in speedier and more focused ways. And they encourage the management of legal disputes in a manner that we believe is consistent with ESG principles, focusing on the G in ESG and asking companies to think about how dispute management fits into good governance. They are clear that they preserve parties' legal rights. There's no compulsory element, and the spirit of the guidelines is about making constructive choices. And we believe they are complementary to existing corporate procedures or regulatory requirements or expectations. So businesses that are accustomed to legal disputes can use them alongside their own internal dispute management codes and processes. So many large corporates, conscious of ESG and reputation, will already have internal processes that focus on efficient and appropriate dispute management. And these guidelines are designed to complement and not replace these. And the guidelines have been effectively peer-reviewed by legal and business. So before we published the guidelines, we ran them past in-house counsel in a number of sectors, including financial services, oil and gas, engineering, food and drink, and communications. And we also ran them past legal consultants. And we thank those people very much for their input. So Guy, over to you.
Thank you very much, Helen, and good afternoon, everybody. I will talk about the guidelines in a bit more detail, but before I do, I just wanted to make some additional observations to what Helen has said. And that's perhaps to try and explain a little bit more the thinking behind them, and for some people who might be wondering whether this really changes the landscape. And I'm going to start with a statement of the obvious, which is that there's two types of disputes, either disputes that are capable of being settled or disputes that aren't. And it probably doesn't surprise you that the vast majority of disputes actually fall into the first category, and I suspect a good number of judges and arbitrators will say that even some that go into the second category should have probably been in the first category. And on that basis, there's then the obvious point that if a dispute is capable of being settled, it's normally in the party's interest for that to be settled as soon as possible, for the simple reason that delay is likely to increase costs and probably will devalue the potential value of a settlement as well. So that's the starting point here, is that actually if we can encourage more people to settle disputes early, then that's probably good for business, probably good for those individual parties. So that's before the pandemic. Then we have the pandemic, and we have the concern that we're going to see even more disputes arising as a consequence of the pandemic. Now, whatever your own views are on that, I'm sure you all heard Chancellor Rishi Sunak describe the current situation on Wednesday as an economic emergency for the UK, with what's projected to be the biggest economic decline in 300 years. Now, that's the UK. Economic impact will vary from country to country, but unfortunately, the broad picture is the same. Now, whatever lawyers and businesses and corporates have seen to date, I think it's inevitable that we are going to see further disputes now, perhaps not the immediate effects of the pandemic, but perhaps more the economic consequences of it. And coming back to what Sir William said in his introductory remarks, that's really what the Breathing Space project is about. It does what it says on the tin, to create breathing space to allow parties to reflect on how they want their disputes resolved. Now, coincidentally, yesterday was the launch of the City UK's Legal Services Report for 2020. And I'm not going to discuss that, but I was taken by the comment of Sir Geoffrey Voss, who will become the Master of the Rolls of the UK in the new year. And he was talking about the creation of streamlined online of an online civil justice system. But he said this: small disputes are as important as big ones in economic terms. Big businesses can generally survive if the resolution of their litigation is delayed by the court process. Small businesses cannot. And that's a really important point in the context of what we may see, which is, it may not be a deluge, but a surge of litigation, potentially at all levels of the business community. If you're a large corporate, you may well be able to dig in and fight for the long haul. It might not necessarily be in your interest to do so, but that you can probably afford it. But there'll be a lot of corporates who are smaller and simply can't afford to do that. Now, if you're with me on what I've said so far, then you'll probably appreciate the potential economic cost of disputes taking longer and costing more than is absolutely necessary. And that's really where these guidelines come in. So we've had a go, we've produced the guidelines, and really whether they have any impact is now down to all of us in terms of what we do with them. So just turning to the guidelines themselves, what you can see on the screen is a summary of them, and I'm hoping that you have been able to access the link that's been shared with you. But what you'll see is we've organized the guidelines into three main areas, which we describe as behaviors. Behaviors A go to what I would call pre-dispute conduct. Behaviors B relate to early dispute resolution, and behaviors C relate to mid-dispute work. Behaviors A, perhaps unsurprisingly, are very much aimed at encouraging parties to take a really objective look, not just at the potential emerging dispute, but actually the contractual performance that is going on at the same time, and really look at whether that contractual performance can be maintained, either having resolved the dispute and moved on, but even if the dispute can't be resolved, whether or not actually the contractual performance and the economic interest for the parties can be preserved and maintained going forward. One of the points we've raised, it's not on the slide, is the possible use of a third-party facilitator. And I've noticed that actually the mediation circles at the moment are exploring this themselves and offering the potential to step in at an earlier stage, possibly even to help parties find changes to contracts that will allow performance to continue. Now, I think it's fair to say that most experienced and mature corporates are pretty good at doing a lot of this already. And what they also recognize is that sometimes it can be really helpful to get individuals who are not vested in the dispute to come and look at this and bring new perspectives. And that's what we've also suggested. Now, if that hasn't been attempted pre-dispute, then it's certainly worth trying it in the early dispute resolution phase, because this is possibly the last opportunity for a party to try and avoid that procedure, that litigation or arbitration process that might follow. Now, we recognise, and I wouldn't be here today if all disputes could be resolved at an earlier stage. We know that's not always the case, and some will have to go into formal processes. But the fact that a dispute has to go into a formal process does not necessarily have to sour an entire relationship. There are many corporate relationships that exist where parties have to simply go off and get a determination from time to time. I know experienced dispute lawyers will have all been familiar with cases where parties have recognized that needs to be done. We simply need a decision. We've got an ongoing contract. Let's just go and get it done. And my experience is when that happens, it's done with an incredible degree of professionalism among all involved. And actually, what can sometimes be a difficult process can actually be a very positive process if the parties really are focusing on getting into a resolution of their issue or a decision in the most economic and clinical way possible. Now, there's a few other points just to mention very briefly. We also wanted to recognize that one of the problems with the pandemic has been delay. And recognizing that actually extensions of time can often be an early marker for disputes. So we've got a practical point here, which is not to really encourage parties not to let contractual or even statutory limitations push parties into an escalation unless that's really what they want. Now, I know lawyers who will challenge me on that and say, no, but what about the party that is bluffing and actually they don't really want to escalate? I should be standing my ground. But I think what I'd say is, well, if that's right, then you'll never end up in litigation. So you've avoided that. And if you're wrong, you're potentially pushing someone into a process that could otherwise be avoided. And then just a few words on behavior C. As I've already mentioned, just because you get into proceedings does not necessarily mean you can't have an efficient and meaningful conclusion of the process. So again, we would encourage parties to use the guidelines to think about early ADR even during the course of the dispute. I don't often see ADR being used in a way to narrow issues, but it definitely happens in processes where litigation is afoot. The parties might choose to amend their cases after mediation, and that's an inevitable consequence of perhaps hearing the strengths of one party's case or the weakness of another's and deciding that the case needs to be honed down. And there are some other procedures that we've talked about here, and I've only alluded to them in the notes. But that was partly because when we drafted these guidelines, there was genuine concern, not just in the UK, but that there really could be a risk of courts and tribunals becoming overwhelmed with disputes, and therefore a recognition that actually what we could all do potentially to make that process smoother is find ways to use the processes available in the most efficient way in order to try and avoid the clogging up of courts and tribunals and other processes. I think that's probably all I should say on the guidelines, but I hope it gives you a flavour.
Thank you very much, Helen and Guy. Just to maybe add a couple of things before coming to our speakers. As Helen and Guy have explained, what this is really about is creating a safe place in which people can focus on conciliation at the 3 stages that Guy identified. And if I may say so, these are commercial guidelines written by commercial people. And just to give you perhaps a visual, it's not a slide, but it's a visual. The guidelines are brief. They're on 2 sides of one sheet of paper, and as we all know, often much more difficult to say things briefly than it is to say them with prolixity. Above all, they're intended to be something that decision makers can quickly read and assimilate and help guide decision making. So thank you both very much for that. And we come now to our first speaker, who is John Howells.
Thank you very much, Bill. Thank you. As you mentioned in the introduction, I'm the chairman of the All-Party Parliamentary Group on Alternative Dispute Resolution. Now, it comes as a great surprise to me to find that there are quite a number of people within the disputes environment who didn't know that we had an all-party parliamentary group on ADR. And it's been going for 6 or 7 years, and in fact, I am the first and the only chairman in that time. So I do feel a great affinity with the whole of the world that we're talking to now. But what does the All-Party Parliamentary Group do? And what it does is to get involved very, very closely with government departments, plus commercial companies and with practitioners in the area. And just let me give you some examples on what it does when talking to government departments. We've had very detailed discussions, for example, with MHCLG on whether mediation can be used in the planning field, because as you know, the government is changing the planning legislation, and the whole of the planning system is proposing to change at the moment. And we feel that there is a huge role that can be played in the planning system by mediation, and we're very keen to get that pushed through. We've also spoken to the Ministry of Defence about how they use ADR within their own contracts, and we've also spoken to the Cabinet Office, but not just about the resolution of disputes, also about how they prevent disputes occurring in the first place, and how we can go about making sure that that is something that we concentrate on. The Secretariat to the APPG is provided by the Chartered Institute of Arbitrators, and that certainly reflects where we're coming from as a group. One of the things that I think that our work illustrates is that we really are advocating a whole of government approach to ADR. And that was one of the first conclusions that came out of a report that I and a Labour MP, John Speller, because this is an all-party parliamentary group, who is my vice chairman, we went to Singapore to see how Singapore was developing its ADR system, and to have discussions with them. And one of the big things that came out of this was that Singapore has a much more whole of government approach. We had very good conversations with, amongst others, with the Chief Justice of Singapore about how ADR could be encouraged, and how it needed government support. And of course, we've seen in Singapore that Maxwell Chambers has provided a great focus. It's not by any means the only focus, but it does provide a focus for this. And we've recommended in the UK that there should be a minister for commercial disputes that looks across the whole of government and takes a view on how commercial disputes should be settled. One of the second things that we came up with there was in relation to the Singapore Mediation Convention, and I've personally spoken in the House of Commons to change the law with private international law with a new bill there, to make sure that we can get the Singapore Mediation Convention in operation as quickly as possible. I also made the foolish promise during the debate there that if they were to bring forward a statutory instrument to get the Singapore Mediation Convention in place, that I would happily serve on it, which I may live to regret in the future. But I think that is a really important thing to bear in mind. And it's an important thing to bear in mind, because if I can put this in the most diplomatic way possible, we do think that there is a bit of complacency that is creeping into the system. We know that most disputes are resolved. The largest number are resolved in London, but that is not going to last forever. The world is changing, and we need to make sure that we are at the front of the process for making sure that we have the right facilities, that we have the right legislation, and that we have the right practitioners to be able to take that forward. So one of the other recommendations that we came up with was that policymakers in both Singapore and the UK should work in collaboration with both the commercial sector and dispute resolution professionals to encourage a culture of innovation that meets the needs of business in what is a post-Brexit, and one hopes very soon a post-COVID world. And I cannot stress enough the importance of that. It's not something that we think that we can stand still on. I said earlier on that we're also about the prevention of disputes as much as possible coming forward. And one of the things that we were stressing in Singapore was the use of conflict avoidance boards as part of complex public procurement projects. Now, the Chartered Institute of Arbitrators has used a conflict avoidance board for its own IT reinstallation. So it is preaching what it practices. It is doing what it preaches there. But I think that the furtherance of that is something that we should put a lot of emphasis on. And the last thing that we recommend is that in both the UK and in Singapore, actually, that there is a tremendous amount of work that needs to be done with professional bodies and those who are providing training to increase the number of non-lawyers that are practicing dispute avoidance and resolution techniques. Now, I know that may be controversial, and I know that some people have questioned that. But let me just explain why I think that's essential. Why that is essential, and that is because I don't believe that it is good that disputes are viewed solely through a legalistic lens. But they need to be looked at through the pursuit of what one might call an ever wider and ever deeper range of dispute resolution options, and the best way of doing that, we believe, is to encourage professional bodies and trainers to provide for the increase of non-lawyers who, particularly in the mediation side, can be very active. The last point that I would make is in relation again to preventing disputes occurring, and that is on Tuesday I'm introducing a private members bill, so this is very timely, to introduce to England and Wales and Northern Ireland an apologies bill. And the purpose of that is because in our experience, people who get into a dispute do not necessarily want to take the organisation to the cleaners and to take them for every penny that they can get, but they are prevented from issuing an apology at the beginning because of the risk of creating legal liability and of it being taken as an admission of guilt in this. Now we know that there is an example of this already in Scotland, which is quite new in Scotland, so it's difficult to see how it should come through. But it does fit in this environment that we're talking about now. It is very much part of the prevention of disputes. And if you think, for example, of major incidents, for Grenfell Tower, for example, I'm not saying that an apology given at the beginning would have made material differences in terms of what people actually did, but I do think that an apology given at the beginning that was sincere and meaningful would have changed the tenor of the discussions, would have changed the outcome that people expected and that they wanted to see. So I hope you will wish that bill well. I mean, the chances of a private member's bill getting through are pretty close to zero, but the Ministry of Justice are keeping an open mind on the bill. And the more that I can make it more like the Scottish bill rather than, sorry, Jan, the Hong Kong bill, then I think that there is a chance that it is something that the government may wish to take up in the future and to adopt. But thank you very much, Bill.
Thank you very much indeed, John. Can I just ask that if people have questions that they post them in the chat room now. So our next speaker is Joan Cross.
Thank you. Thank you.
Hi, Joanne.
Hi. So from me, I'd just like to give you some perspectives from an in-house commercial perspective on these guidelines. And to start with, pretty obvious comment which Guy's touched on, there is no doubt that we are living in extraordinary times in terms of the economic hit to the global economy. Many companies are facing huge financial challenges. Some very sadly will not survive, and it's likely, I think, that the repercussions will take years to play out of this pandemic. And therefore the need to reinvent and adapt for corporates will be of the highest priority. So given all that context, it seems to me that these guidelines provide practical steps on how to approach disputes in a fair, reasonable, good faith way. They encourage parties to fully explore, as we've heard, the options of negotiation, mediation, ADR, in a more heightened way than I think perhaps they would have previously done. And from my perspective, it has to make sense, I think, to pause and take stock before embarking on protracted and expensive litigation or arbitration, given the current context that we all face. So I think the commercial imperative to consider these principles in these guidelines is obvious in this climate. And so I would describe them as important and timely reminders to all of us engaged in dispute resolution to promote the efficient resolution of disputes now more than ever. Having said all of that, it does go without saying that as ever with dispute resolution, one size does not fit all. And there will certainly be, I think Guy touched on this, but there will certainly be some disputes where formal litigation or arbitration cannot be avoided, the stakes considered too high, the dispute considered too complex. So I think inevitably this will not catch everything, but having a mind, even for those disputes, to the most proportionate approach and testing the potential for early resolution or potential for resolution after the dispute has kicked off. I think that has to be worthwhile in many cases. It's also obvious, I think, to say that not everyone will buy into this approach. Indeed, I can see the scenario of some feeling that the existential threats that they face dictate that they have to follow the most aggressive, most intransigent approach possible, and I think that's inevitable. But I would like to think that many of us already strive to approach their disputes in the way in which these principles are setting out. So I think for those sorts of corporates, then these guidelines can be seen as a very helpful reminder. And as Helen has mentioned, that they may very well be complementary to existing internal processes that corporates have. So I can certainly see that may well be the case for many. For others, and possibly smaller corporates, but not necessarily, they may not litigate or arbitrate very frequently. And so I think these guidelines do provide a valuable checklist for those companies on how to approach dispute resolution with the big picture in mind, minimizing costs and time taken to resolve disputes. I think going forward, a key goal of business has to be to free up companies to rebuild, reinvent post-COVID. And the time and attention of their senior execs and management has to be to focus on this rather than protracted disputes. And so I think these guidelines provide helpful encouragement to view disputes through this lens of commercial imperative, frankly. Just as an aside, in terms of reflecting on how the COVID pandemic has influenced us and some, and other corporates, I'm sure. I know it's highly likely that a lot of people have spent a lot of time recently refreshing their understanding of force majeure principles, and probably looking at force majeure from the point of view of both the claimant and the defendant perspective, possibly both. Such claims are, though, notoriously costly to litigate. They often require detailed expert and fact witness testimony. And I think it's obvious to say that causation can also be complex to prove and very easily challenged. So before embarking on formal force majeure claims, I think it's likely to be very worthwhile to consider whether a negotiated resolution is possible, and to put real efforts into that, as I think these guidelines would recommend. So in summary, I believe the potential for significant cost savings, together with the value of freeing up companies to focus on their core businesses or to building new businesses post-COVID, mean that the aims of these guidelines are particularly pertinent in the current context. And so I would commend them to in-house counsel and external counsel as very worthy of consideration and an eminently sensible and timely reminder of good practice for us all. Thanks.
Thank you very much indeed, Joanne. The questions are starting to come through on the Q&A. If you've got questions, please do put them on the Q&A. So, Janbo. I hope she's there. I just see.
Apologies, I had to mute off. Thank you very much, and it's a pleasure to be here.
Oh, welcome from Hong Kong, I think.
Indeed. Indeed, I am in Hong Kong at the moment, and I welcome these principles in this concept note 3. I think they speak very much to the traditional practices out in Asia already, and how I think that they're nicely tied into what we have been wishing for in dispute resolution, but have been caught up too much in the business of resolving disputes than actually the practice of resolving disputes over the years. So I see this COVID moment as really an opportunity, and an opportunity for a holistic review of dispute resolution. And I applaud what has been done, not only in this concept 3, but indeed also concept 1 and concept 2. This concept 3, however, is one that I envision will be most well exercised and utilized by practitioners and in-house, and indeed adjudicators such as myself. The ideas of these principles being packaged into one double-sided sheet is one that serves as a practical reminder as to what we are actually doing when we are resolving disputes. We are not tied up in all of the bells and whistles that have been developed and all of the innovative techniques that have been developed in arbitration over the years, which, while helpful, do also or can also serve as a hindrance in resolving the dispute itself. And in fact, we have seen these many techniques being utilized as guerrilla tactics and delay tactics over the years. And so this set of principles that have been put in place certainly, I think, shows and reminds all of us practitioners as to what we are aiming to achieve in resolving disputes. I see that what we have seen over the years as being a gloves off approach once the dispute actually enters into arbitration or litigation. And certainly that is true in Asia and I think around the world. And that kind of turning point is one that it's hard to come back from once it is triggered. So the three phases of utilizing these principles, as I see it, are pre-dispute, post-dispute, and concurrent dispute. And by dispute, I mean the trigger point. In terms of the pre-dispute moment, we've indicated the maintenance and the preservation of contractual disputes. And we have seen this play out in many of the COVID situations these days. And certainly, for example, the Supreme People's Court in China have issued judicial opinions to facilitate the preservation of of contractual relationships. And they are in a way to allow for the carrying on of contractual relationships during the period of COVID. There are also other schemes that have been developed. For example, the Singapore, what is it called? The temporary relief for inability to perform contractual obligations due to coronavirus. This scheme or this temporary relief comprises of an initiative not by lawyers, but by a pool or a body of assessors who are actuaries or accountants who can actually resolve the dispute practically. And these forms of schemes and these directives from governments are meant and intended to ensure that these contractual relationships can carry on and continue through this pandemic. The other angle or the other phase that is useful to draw attention to is that of the concurrent phase. And that is the moment in which the arbitration or litigation is commenced, but there are still ways in which you can off-ramp that system. And certainly arbitrators and adjudicators now have to be mindful of these possible moments for settlement and utilizing a set of principles such as embodied in this concept note 3 is certainly a useful tool by which to remind adjudicators as well as practitioners alike. As well in Asia, what we're seeing is a shift in ethos of resolving disputes. And this has certainly been emanated by the signing of the Singapore Mediation Convention, as John had mentioned earlier. And what this creates is not just the tool itself of enforcing mediated settlements, but rather an infrastructure and a holistic culture in the region for utilizing mediation in a way that it's never been used before and recognizing its usefulness for resolving disputes. And while this Singapore Mediation Convention has one particular function, and the broader function being creating an ethos, it is also being executed by way of the Singapore International Mediation Convention, which has a COVID-related scheme for expedited mediation. Very recently, SIMC has also joined up with the Japan International Mediation Center to allow for joint resolution of disputes via mediation. And these schemes are actually being executed in this way. I should also mention one of the other off-ramping or settlement of disputes during the course of arbitration or litigation, but in arbitration in particular, is in fact legislated in Hong Kong and Singapore, whereby there is a provision which allows for mediation or conciliation by the same arbitrator during the course of an arbitration, and facilitates for that kind of mechanism. Now, this ARB-Med-ARB concept has certainly been well discussed over the years and was quite popular in previous years, when, a few years back, when there was a famous case called Gaohai Yang versus Kenai coming out from the Chinese enforcement of a Chinese award in the Hong Kong courts. But this form of dispute resolution is, in fact, has become part of the structure. And so this off-ramping and the possibility of settlement during arbitration is something that I think we can further enhance around the world. And finally, and very briefly, is the post-dispute phase of ramping up or ramping down after a dispute arises, and finding ways that even after an arbitration award is rendered or a judgment is rendered, there are still ways, there still could be a ways to go in the enforcement of such an award or a judgment. And at that point, there are still, it is not still all said and done, because there will still be opportunities for settlement or bringing this to a more tidy closure. And again, this concept note 3 can continue to serve as a useful reminder even during the post-dispute phase.
So Jen, thank you very much indeed for that. The act that you mentioned, the Singapore COVID-19 Temporary Measures Act of 2020, thank you for picking that up. In fact, the term breathing space project took its inspiration from that very description that the Minister of Finance in Singapore mentioned the Singapore Parliament when he was introducing the legislation in April. It only took about 2 or 3 days, by the way, from beginning to end to get onto into the system and onto the statute books. But thanks for drawing attention to that. So finally, John Fellis in New York, and John, thank you for getting up early to join us.
Thank you, Bill, for having me. I'm just going to give a few observations from US perspective on concept note number 3. First, there has been no equivalent initiative on this side of the pond by lawyers as distinguished as Bill Blair and Helen Dodds and Guy Pendell and Adam Johnson. And I want to commend you all actually for spearheading this important project. I think it's a wonderful initiative, and I hope taken seriously everywhere. Even though there is no equivalent initiative here, some aspects of what you see in the guidelines have been adopted in the United States. As one example, guideline B7 asks parties to agree to extensions of contractual or statutory limitations periods where to do otherwise would likely result in proceedings having to be issued. This is obviously an important guideline because it stops parties from racing to the courthouse immediately for fear that the statute of limitations may expire on a claim. What has happened in the United States, where many statutes of limitations are a matter of state law, is that governors of certain states have issued executive orders extending limitations periods as a result of COVID. Governor Andrew Cuomo in New York, for example, first issued one in March 20th of this year, and has repeatedly extended the statute of limitations through the use of further executive orders. Now, I doubt very much that the reason that gruff and combative New York Governor Andrew Cuomo read Concept Note 3 before issuing that order. You never know. I don't want to rule it out, but I suspect he was less motivated by trying to discourage people racing to the courthouse and more motivated by the fact that New York courts and law firm offices in New York were shut down for part of the time as a result of COVID. And so it was difficult for parties to actually get their suits on filed. A second observation I would make is that, at least in the field where I spend most of my practice, international arbitration, one of the most striking things is that the disputes that were pending before COVID have gone ahead with little by way of breathing space. The main phenomenon I've observed is that parties made requests in the early days of COVID to postpone arbitration hearings, not because they wanted to talk conciliation or settlement, but rather because they wanted to have live hearings. And there was a tendency in the early days where parties had hearings in April, May, June, to say, let's postpone these hearings until autumn, because that way we'll be able to have them live. Now, that proved to be very optimistic, because what happened when the autumn came along is that parties, in my experience, tended to go ahead with virtual hearings in the autumn rather than push them on again. So it's, you know, my guess is that most of us practicing in the field of arbitration have been through several sets of virtual hearings over the last few months. Third observation is I think you can see this both anecdotally and generally. There are now more and more cases arising out of COVID. And crudely, very, very crudely, you can put these into two categories. One is where COVID is the basis of an affirmative claim. The most prominent of this type of case is the business interruption insurance case. And you've seen these in the United States, claims brought by, for example, medical clinics or restaurants that have been adversely affected both by the pandemic itself, but also government action taken in response to the pandemic. The restaurant shutdowns, the limitations on restaurant capacity, and so on. Most such claims have been dismissed, as I understand it, based on policy language excluding viruses from coverage. But some of them have gone forward, and you know, it remains to be seen how they turn out. But there are some of those cases haven't been dismissed at an early stage by US courts. And I suspect that they will be hard fought, that the insurance won't want to have one bad precedent issued by a court on certain policy language. So we will see what happens there. The second type of COVID case is the one where COVID operates not as an affirmative claim, but as a defense to a claim of breach of contract. And here I'm beginning to see such claims in my practice relating to the supply of raw materials in the commercial property industry, in the entertainment industry, for example, where live events have been impacted by COVID. And I think it is here actually in these types of cases where the guidelines will be most useful. Which brings me to my next point is how receptive will the United States be to such guidelines? I have learned as a disputes lawyer that clients come to you with different mindsets. Some want a peacemaker, some want a lawyer who will try and resolve the dispute or at least put an end to it as quickly and as cheaply as possible. But many don't come to you with that mindset. They want a gladiator. And I suspect this may be more the case in New York than in other jurisdictions. But what they are looking for is a lawyer willing to fight to the hilt, who've used litigation as a blood sport. And in such circumstances, when a client comes to you with such a mindset, you actually have to be very sensitive about how you broach the subject of settlement. It's not always that easy to say, well, I know you want to scorch the earth, but here's a safe place for you to take a breath and consider settlement. It doesn't always work. A client's response to that may well be, look, I've just got the wrong lawyer. I don't want you. I want somebody who's going to fight. And I think one of the benefits of these guidelines is it actually gives the lawyer who believes it would be prudent for the client to consider settlement. A way to broach the subject without, in a sense, making it look like you're the one suggesting it. These are guidelines that have been issued by a distinguished group, a distinguished organization. They are short, as Bill pointed out. You know, I read once that advisors to Donald Trump used to write memos shorter and shorter because he wouldn't read more than a page or two. And then I also read that they started putting his name in memos because he would only read the bits around his name. But you know, I'm not saying Donald Trump would read these. His name isn't in them, as last time I checked. But they are easy to read. They're very quick, easy. They make a lot of sense. So I do think they could be a useful way to raise the subject of settlement and conciliation with clients who would otherwise not think of it. Let me turn to a fifth point and just give, you know, the way I've experienced COVID defenses come up in cases I'm involved in has been procedurally rather than substantively. And I've actually had two cases recently, one as counsel, one as arbitrator, where COVID has been raised. And I was surprised. And let me tell you what happened in both. In one of them, we had a deadline to file a statement of defense. One of our fact witnesses, one of our main fact witnesses in an international arbitration proceeding, had contracted COVID and was in hospital shortly before the deadline. I asked the other side, will you agree to an extension of time? And they said no. And eventually we had to resolve the dispute with the arbitrators who did grant the extension. I likewise have a case right now with a similar posture where I'm one of the arbitrators, and I won't say too much about it because it's a pending case, but similarly, there was a request for an extension based on COVID, and one side objected quite strongly to it. And what I think is a fear that parties have, and I'm not sure how to guard against it, is suspicion. It's suspicion that a respondent is just using COVID as an excuse, that actually there really isn't an issue. They're just relying on it to try to avoid fulfilling obligations, in this case procedural. But I suspect the same mindset might in fact, if I can use that word, might infect claims on the merits in cases. You know, in cases where the parties have a long-standing contractual relationship, a long-term supply agreement, for example, and it's otherwise gone smoothly, I suspect there'll be suspicion. But in cases which are a one-shot deal or shot contract, I think you know, invoking COVID won't be an automatic get out of jail free card. I suspect there'll be fights about it. Just a final observation, and that is conciliation always has to take place in the shadow of the law, and parties need to understand their rights and obligations before they can have a realistic discussion about settlement. And I just want to pick up on something Helen noted. You know, civil law offers much more scope for courts to change the terms of contracts in response to changed circumstances, or to allow considerations of good faith to trump contractual language. That is much less the case in common law jurisdictions like the United States and England. And litigating force majeure clauses can be very, very tricky because they raise two analytically distinct questions, force majeure clauses. And one is, has there been an event of force majeure? And the second is, has this prevented or impacted contractual performance? The first question is often easy. Has there been an event of force majeure? Force majeure clause could be broadly worded. It could have a catch-all provision like any circumstances beyond the reasonable control of the party. It could mention act of God. It could mention a pandemic. It could mention government action, which would include government action in response to a pandemic. Parties are likely to have a reasonable case that there has been an event of force majeure within the terms of their contract. The trickier question is, has it impacted performance? And that will depend very much on the wording of the contract as a whole and the facts of your case. Let me give one example of this. just supposing you're supplying a raw material, uranium, to a nuclear power operator. It would be one thing if the contract named a source. So it would be uranium from this mine in Kazakhstan. And as a result of COVID, you couldn't operate that mine. It was shut down or impossible to operate. That would be one thing. On such, if the contract is worded that way, there's a single source and it's been impacted, you have a good case, I think. But take a different example. You're a uranium supplier, but no source is named in the contract. You operate mines, but the contract itself doesn't specify a mine. Then I think the argument on the other side will be, well, you should just buy it on the open market and supply it to us. Nothing stops you from doing that. And so, it's important to note that a force majeure clause is not a get out of jail free card. As Helen pointed out, they're expensive to litigate, can be expensive to litigate. And I think you need to understand your rights and need to have a lawyer review your contract before sitting down to negotiate. You can't go into this thinking COVID lets me off the hook. And with that, I will stop.
Thank you very much indeed, John. Thank you for all those excellent presentations. We've got really two themes in the questions, and let me put them in this order. That picking up something that you mentioned, John, we have a good faith theme, and we've got the social ethos theme, and they're both great questions. Now we'll end at 2:15, so we don't have a whole lot of time to discuss it. But Helen and Guy, you see the question that came in from Audley Shepherd, of course, is the partner in charge of Clifford Chance's arbitration department and chair of the LCIA. What about this? Just in a few sentences, it's picked up by another questioner as well. Are you edging towards some kind of good faith, perhaps implication, or are you really offering this instead and sticking to what certainly has been the English law view, that good faith performance doesn't form part of our law? It'd be great to hear you both on that, but starting with you, Helen.
Oh, well, thanks, Bill. I'm a bit old school in this, and I like the fact that it's very clear, the English law, you can have a good guess at what you're going to get, and it doesn't have the same good faith provisions as other laws, and there it is. And I think it does create predictability, and I think what we're trying to say is not that any specific thing should happen with the guidelines, but just that you have the flexibility, and you don't need to go along the illegal guidelines. You need to do a deal or come to a resolution that suits all the parties. That said, obviously another great thing about English law is that it evolves very quickly in terms of precedent, and it just builds and creates. It's a sort of distributed ledger type of activity. And that's one of the beauties of it. So actually, I would expect to see some sort of natural evolution in relation to good faith taking place in English law, which will be generated by the process of the law itself, rather than some external influence. So that's my take on that question.
Thanks, Helen. Guy.
In our introductory notes to the guidelines, we actually did discuss this a little bit, because obviously it was a topic that was raised in concept notes 1 and 2 as well. And I'm sure Audley asked the question because we perhaps sat on the fence in relation to that point. But the reason we did is because actually we made it clear that what the guidelines are not seeking to do is actually change the existing legal rights and obligations that may arise under a contract, because it's a very bad thing in my view to try and do that after the event when people have already made their economic calculations as to how they want to contract, which probably gives away a little bit in terms of my thinking that I think generally, as Helen says, we probably will start to see good faith creeping in, but I suspect it's going to be confined to certain areas. And indeed, we've already seen a few cases that have introduced this concept through the idea of relational contracting, with Bates and Post Office and a few others that have considered what the principles would be. And of course, with Lord Justice Leggett now in the Supreme Court, we may have more on this as well. But I think the reality here is that it would be a big departure for the principles of English law to introduce more of a broad good faith concept, because it does go against that idea of certainty and the ability to perhaps try and get more clarity on what the outcome is going to be.
Thank you for that, Guy. Joanne, is there anything you'd like to add to that particular point? And then I'm going to come on to the ethos aspect of the questions.
No, I mean, I tend to agree actually with what Guy and Helen have said on that. I think it would be, I can see the English law position evolving somewhat here, and I think that would be fine. But I don't think it's the place of the guidelines to enforce that. Nevertheless, of course, we will hope that people approach the attempt to resolve disputes in a good faith way. So that's a slightly different point to whether English law would change or not.
Thanks. Just picking up a point that Janbo made. A Chinese judge was talking to me the other day about the provisions that the Supreme People's Court have laid down in Chinese law, which is a civil law system, which gives the courts power to adjust contracts. And you see provisions like that in French law and German law. And he said to me, actually, our judges have not been at all keen to do this, because it's very, very difficult for a judge to second guess what the parties the parties want. So judges have tended to avoid it, but I simply pass that on as a little bit of something that I've had from a good authority anyway. But Audley, thank you for very much for your question, and Andrew Hildebrand, thank you for your addition to it. And that, I think, is something that we could perhaps return to in the end. But I'd like to, before we do close, give each of the speakers a chance to talk about this social ethos, because in a way, each of the speakers has touched on this, and it is really important. And just so you know, the very last question is going to be about whether there's been any feedback. But we've got very limited time now, so just in a few sentences, what about the social ethos? And John Howell, start with you.
Thank you. I think the social ethos is very important on this, which is why I made my point about trying to broaden out the people that are involved with disputes. On an international mediation that I was involved with, there was not a single legal point that came up, but the parties to it were very happy to agree a social agreement to be able to take this forward.
Thank you very much, John. Janbo.
Yes, I think there is very much of a social ethos, and I think that, I think the original question was whether it was in China, but I do think that globally there is this this ethos and this desire for settlement outside the courts. I think it's interesting to hear John's international mediation experience, because I think that that's where the social ethos may kind of fall apart, because there isn't an understanding of cultures. And I think that is where some of this the tension lies with dispute resolution. But in short, I am hopeful that we can continue to come out of this pandemic with a better social ethos of building bridges rather than taking it to the gladiator all the time.
A very, very good analogy, if I may say so. Joanne.
So I suppose this sort of links in with hoping that people will, it's almost like an ethical approach, a more ethical approach to how dispute resolution might be handled. And I absolutely think that's going to be very important, and linking into ESG goals as well. So I think it is important, absolutely, and it'll be something that probably will get more and more prominence.
Thank you. John Fellas.
You know, crises can bring about changes both in law and in the social norms and social ethos. Just for example, you know, in Germany, under German law, it is actually courts do exercise the power to vary terms of contracts, and that power originated from the hyperinflation of the 30s, where you'd enter a contract on one day to sell something for 100 Deutschmarks, and the next day 100 Deutschmarks was worth a zero. And so that power came from that crisis. That change in the law came from that crisis. And I think what we are seeing, and I think it's more than just lip service, although I do fear the advertising industry does pay lip service to this notion of we're all in it together. It's a motif I think we've all heard over these last few months, but I do think it's changed people's attitude to the way they live their lives, and hopefully will resonate when people have disputes.
Yeah, it's going to change a lot. You're quite right. So we've only got a couple of minutes left. There's a question that's come from Nikolai Goka in Singapore, and it's about feedback. And I think it's appropriate if we give the last few minutes of this event, and please just a few minutes, to both Helen and Guy. So Helen, first from you, and then Guy from you.
Well, we haven't had any feedback, and I don't know whether we're all, whether we're still at the talking stage. I mean, I'd love to get feedback. So really, I suppose my answer is to ask the audience for their feedback. And I think there is a place where you can contact BIICL, or you could find us, I'm sure, if you wanted to give some feedback or some initial thoughts, because I think the next step is now to push this further into its practical application, which was always our aim.
Thanks, Helen. Guy.
Well, I haven't had any feedback either, but actually I wasn't expecting any feedback yet, because I think this ties into your earlier point about social ethos. And actually, I think this is about nudging people more into the direction of considering different approaches and different bases for resolving disputes. And I was interested in John's comment about clients sometimes still wanting gladiators, because what we don't think about is the amount of time that's been spent resolving disputes through other means in the past. So, for example, dueling has probably been around as a way to resolve disputes for far longer than modern dispute resolution. And yet no one would consider for a moment that that would be an appropriate way to resolve a dispute now. And I relied on the very authoritative source of Wikipedia to tell me that dueling did not stop because it was banned by legislation. In fact, it had been banned by legislation for years before it actually finished. It stopped because public opinion moved against it. And I think this comes back to this point, is actually you have to move with the times. And it comes back to Helen's point that actually corporates now are thinking about ESG, and dispute resolution is a part of G, and having a more of a social ethos around that is certainly something that we would be encouraging people to think about.
Thank you very much indeed, Guy. And so let me draw proceedings to a close. I just want to say what a great job I think that Helen, Guy, and Adam have done on this. We're at the beginning of this now. This is something for a time. First in my lifetime, by the way, and as you can readily see, I'm not particularly young anymore. That the world has really genuinely reached something of a fork in the road. It's definitely that kind of moment. And it applies to litigation just as much as it applies to anything else. Now, in closing, I want to thank our brilliant panel. They've done a fantastic job. Thank you particularly for those who've joined in time zones that are less than friendly this time of day, Janbo and John, although John in New York, I'm sure you've probably done a half a day's work already. And finally, last but not least, thank you all who've joined the webinar. We really appreciate it. We hope that you're as enthusiastic about this as you can tell we are. And finally, I want to thank the British Institute of International and Comparative Law. They've done a great job in pushing and pressing issues of this kind. Thank you all very much.
Thank you.
Thank you.
Thank you.